Welcome to the future of political consulting by the AAPC, where we explore the evolving landscape of political consulting in a rapidly changing world. The AAPC is a bipartisan membership organization that represents professionals working in the political consulting industry. Today, we will be listening to AAPC Director of Advocacy and Industry Relations, Julie Sweet, and Jason Torchinsky, a partner at Holtzman Vogel, discuss the new AAPC Deepfake Law Compliance Guide.
Welcome, everybody. Jason, I'm really glad to have you here. The AAPC has developed the Deepfake Compliance Guide covering the 26 states that currently have laws regulating the use of AI and digitally altered media in political communication, plus a few other handful of states that have name, image, and likeness laws. Invited you here today. You help us out a lot at the AAPC in terms of laws and compliance laws, but thought it would be helpful to bring a lawyer on to actually talk about some of these laws as well. Um, what's your hot take? 26 states, different laws.
Right now, a big mess. There's a real hodgepodge of what's required, what's prohibited, what's allowed, what the penalties are. And what we don't have, because most of these laws are so new, is any history of enforcement actions or challenges to enforcement actions that we can rely on to advise clients about exactly what's going to be permitted or prohibited in various states.
So a bunch of laws, a bunch of different states, very little clarity on what any of it means.
Right. And unfortunately, we're going to need, I would say, 2 or 3 election cycles of allegations and responses and decisions by the various enforcement authorities, whether it's courts or campaign finance regulators, to sort of sift through what these rules are going to mean in the longer term for the practice of political consulting.
So that's 4 to 6 years. That's putting us past around 2030
Yep.
after a presidential, another midterm. And where's the technology going to be at that point?
If I pretended to tell you where that would technology would be, I'd be in the hedge fund industry making a lot more money than I do as a lawyer. But I mean, just to give you an example, I mean, there was a complaint filed in Wisconsin. It was the first sort of AI related complaint. It was filed in the Wisconsin Supreme Court race. It's pending in front of the Wisconsin Elections Commission, and it involves the new Wisconsin AI law. And basically what happened was the candidate uh, took a photograph of his opponent. There was a photograph of her full color smiling, and it got changed to that old style, sort of like gold and black sort of teletype. And the smile went to a frown, and that was used in the campaign ad. Um, and it did not contain the Wisconsin required disclaimer. That's been pending for 7 months now with no movement. The candidate that's the subject of the complaint has apparently responded, and it's been sitting in front of the Wisconsin Ethics Commission or the Election Commission, and we don't know the outcome of that one yet.
So the Wisconsin Ethics Commission has to make a decision as to whether what are some of the arguments. I think the campaign that made the ad said, well, actually, yeah, we altered the image. That's not up to debate, but we didn't use artificial intelligence to do it. We just use good old editing techniques that we've been using for the last 10 years.
Right. And then, the question is, right, if Adobe Creator or Adobe Acrobat is allowing, AI to be used inside of Adobe, even though you may see it as the same technique you've been using for years, if Adobe has changed how they're sort of operating their editing systems, right? Is it really AI now, or is it just, old and traditional? So, the Wisconsin Election Commission is going to have some real decisions to make here.
And do you think if they do, however they come out on the end of this, is it going to set precedent for other states, or are the state laws just too different to really help us better understand how California might enforce these rules?
So I know most of the audience here are not lawyers. So what happens when there's kind of a new area of law even if, a Wisconsin decision isn't binding on Idaho, if the only other state court that has decided something is Wisconsin, the Idaho court will at least look at the Wisconsin decision and say, this is what we think. We either adopt the reasoning of the Wisconsin decision or we reject the reasoning of the Wisconsin decision for the following reasons. And then we'll start to develop either agreement among the state courts or differences among the state courts, over time as there's more of these enforcement actions, right? I believe the Wisconsin process, if the Wisconsin Election Commission, whoever has an adverse ruling, I think can appeal it to the court. So eventually, I think there'll be a court decision on this one, which then obviously other courts will be able to look at as courts in other states look at it.
Hmm. Hmm. So how Wisconsin goes could affect some of these other states. Are there other complaints that we're aware of?
So there have been a number of lawsuits against a number of these statutes before they've even began any kind of enforcement action. X sued over the Minnesota law. X won an injunction, as did some others, against the new California law, or against portions of the California law. So I think what we're seeing right now is more challenges to the laws generally. And the courts, at least the federal courts, are having a really hard time finding how to justify what these courts have so far viewed as infringements on speech.
Hmm. Well, okay, let's go back up a little bit. Like, what are these laws trying to do? Why do they exist in the first place?
Because politicians are scared of what AI might do. That's why these laws exist. There is concern that people are going to do things that are deceptive with AI, and that those deceptions are going to impact campaigns. Probably the highest profile deception that we've had was the fake robocall using Joe Biden's voice that was actually created by, I kid you not, the champion fork bender from Louisiana, who created the fake voice of Joe Biden telling New Hampshire Democrats not to vote in the upcoming New Hampshire primary because it didn't count. Ultimately, the FTC, using existing laws, assessed a $6 million fine. And I think there are criminal charges still pending in the state courts, although I don't know the status of the criminal action.
I think he was exonerated by a jury.
Okay. So, and that's quite possible because these laws are a real challenge. So if he was exonerated, but he still paid a $6 million fine, it was still an expensive thing to have done. Plus however many, 2.5 years of litigation over this and investigations. So, you know, people are afraid of that, right? People are afraid of, a video of their candidate not saying what the candidate actually said. There's a great video online of Barack Obama explaining quantum mechanics, which is not real. It was put together by somebody using one of these voice generators, but it's him and he's moving and he's speaking about quantum mechanics and he's talking about cats sleeping and not sleeping at the same time. Just obviously it's not Barack Obama explaining quantum mechanics, but people are concerned that something like that could show up in a campaign.
So what is like what jumping into all of the different kinds of laws that we have. So there's kind of three big buckets of laws, right? Where the federal Congress actually passed a law recently, the Take It Down Act, which addresses the non-consensual intimate images, right? So the Scarlett Johansson things of the world, of which you most often targeting women, things like that. So and those are everywhere across many states, but really don't apply, and I wouldn't see much reason for those laws to get applied or complaints in political communication, generally speaking.
Hopefully not.
Hopefully not. And then there's the name, image, and likeness laws, and that's like the Tennessee Elvis Act, right? Like you can't recreate somebody's voice and then profit off of it in kind of a commercial. I'm curious, I think there's still some debate as to whether those laws can be applied, right? Like if it's for commercial purposes, it's pretty clear, but could some of those publicity rights be used as a way to kind of go after a political campaign?
I think it's quite possible. I think it depends on the language of the statute and the person at issue, right? Because there are some people who enter politics who have different potential commercial uses of their voice or likeness than others. Um, and I mean, think about how many former talk show hosts, actors, actresses, singers have gone into government over the years or have sought elective office over the years. Um, I think the average candidate who just was doing something local in their community, it may be a little harder to apply the more traditional name, image, likeness laws. Um, but I think, look, if you're the candidate who feels like someone has wronged you by using some modified version of your voice, I think you're going to look to your lawyers to try anything to go after the people that you feel have wronged you.
Hmm. So then there's the laws that have been written almost expressly for political communication. And that's the ones where there's 26 states that now do this. Can you just kind of walk us through what are the big things that people should be thinking about when they're starting to use or thinking about using AI? Like, what are some of the big kind of risk assessments that they need to do?
So generally what you find is that there's not what you're finding in these laws is essentially a combination of either prohibitions or disclaimers. And so if you're going to use AI, it's worth talking one to your candidate to make sure that the candidate that you're supporting is okay with this. And two, talk to the counsel for the campaign and figure out what applies in your state. These statutes use all kinds of different language. They use all kinds of different triggers. They use all kinds of different references to technology. There are different time frames, 30 days, 60 days, 90 days, sometimes year round. So there's a lot of factors to consider that really, given the wide variety and the application in currently 26 states, it makes it really hard to give any specific example.
Hmm. Yeah. When I was writing that compliance guide, I just kept coming back to there is just no real consistency. And you would try to put these states into different buckets and these laws into different buckets. And what you ended up was just nothing that was real way to categorize or to say these states are all this way. I mean, I think the closest that we got is you have a couple of states that have the tool, right? That say that if you use AI, you need to disclose it. And then there's another bucket of that if it's just misleading. So you represent somebody doing something that they didn't do or saying something they didn't say, then you're probably going to need some form of disclosure. And then there's the last one that's like, okay, we think about AI, we think about so the tool, then we think about whether it's misleading, and then this question of intent, which I love your thoughts on because it says if you have the intent to harm the electoral prospects or harm the reputation of the person depicted, oftentimes the candidate. But isn't that just all campaign ads for the most part? So
which is
aren't
part
they
of the
all going to qualify under these laws?
which is part of the problem. And I mean, you're right that there's no easy sort of framework to put these things into. And I also think it's important for political consultants to understand there's not like a left, right, Republican, Democrat divide on these things. It's not like you're like the red states are doing this, the blue states are doing this, and the purple states are doing this. It's not this is not an ideologically categorizable sort of phenomenon that we're seeing in these 26 states. I mean, you've got states like Tennessee, California, Montana, Colorado, Texas, Washington, Idaho, all doing, all taking action in this area. So it is really hard to categorize. And that is what makes it tough. But back to your question on intent, you're right. A lot of these states say intent to harm electoral prospects. And you're right, right? If you're talking about your opponent and you're a political consultant, you wouldn't be running the ad if you weren't trying to benefit your own client. So, I think I almost feel like that probably takes the intent out of something you could really argue in defending one of these. Because it would be really hard. I mean, if you're a Republican in Washington State or a Democrat in Texas, like why would you run an ad that isn't intended to harm the electoral prospects of your opponent?
Right.
Kind of the purpose of political advertising is to convince people to vote for your guy and against the other. So I think they use the intent language, I think in the specific sort of candidate A versus candidate B context, it's a little bit easier. Where I think it becomes a little more challenging is, for example, let's say you have a super PAC playing in a multi-way primary in a state. Well, I don't know. Intent may be a little less clear when you start applying this to sort of multi-candidate primaries in the same election. Where it's a little bit less clear than, say, a Republican versus a Democrat in a general.
Mm-hmm. Mm-hmm. One of the other kind of big questions is are these laws really meant for people to have to disclose when they use just background editing? There are a few laws that say, substantive edits or de minimis edits don't qualify, etc. But like, how I can't imagine that these legislators were like, we want you to be disclosing every single time this tool is used, because it's kind of like telling you that you should label with Photoshop versus an Excel spreadsheet versus, right?
Right.
So where can folks think about drawing that line?
So, I mean, let's say it's your own ad, right? It's Julie's congressional campaign, the picture of Julie that the photographer took or the videographer took, and you need some color correction, right?
Mm.
And if AI is built into the tool that's doing color correction because the white balance is off or something, I don't think any of these laws are intended to get at that. Although the way they're written, some of them say if you use any AI tool or they use some different language in the creation or modification of an ad or a video, then it's potentially covered. Although I don't think that's really what they intended. I mean, going back to this Wisconsin Supreme Court example, the defense from the candidate whose campaign altered the smile to the frown and changed the color said, look, these are just basic like video editing tools we've been using for decades. This isn't artificial intelligence. Um, if I were the investigator, I'd kind of probably ask, like, what tool did you use? Right? What version of whatever software did you use? And then you need to figure out whether, under the language of the Wisconsin law, if AI is embedded in that software program.
Well, doesn't that kind of get at, like, is our definition, now that we have this word kind of deep fake that we can use oftentimes inartfully, that before the Wisconsin law, making an edit of that type wasn't against the law, whether or not it was made with an AI tool or a regular editing tool, right? It was just changing the way that the candidate looked to meet the particular ad that we're trying to create. So is that the trend now? Like, things that were once legal and kind of accepted practices, there's now a way to go after that?
I don't think that was the intent of any of these laws. And by the way, in Wisconsin, it's not even a prohibition. You just have to put a disclaimer on if you use it. So it doesn't actually stop you from doing it. It just, like we're all used to disclaimers now, it would just require another disclaimer in the ad. So it's not, at least in Wisconsin, it's not a prohibition. It's you can't do this unless you put on the disclaimer.
Mhm.
So I think that's an important thing to consider. But there's a lot of line drawing here. For example, I don't know if you remember in the 2020 presidential primary, there was a DeSantis ad where Ron DeSantis was speaking, and he was speaking at an outdoor event, and someone added a jet flyover. It was like a 5-jet formation that like flew over his head. In the actual video, there was no 5-jet formation that flew over his head, but in the ad, that had been added digitally. Is that a deep fake? I don't know. I mean, did he actually like speak outside in front of a crowd and say those words? Yeah. Did 5 jets fly over, streaming wet, white, and blue smoke? No. Um, it was added in the editing process. Is that fake? I don't know. There's some line drawing that has to go on here, and exactly where that line is going to be drawn is not clear.
Mhm. So on the disclaimer, I hear your point that they all say don't do deep fakes, but if you put a disclaimer, there's some will say if you add a disclaimer, then clearly you're not trying to deceive anybody, right? And then there's others that just say anytime you use it, you've got to put it on there. So it's actually required. But there is some early research, though, that we found, our friends over at the NYU, that there is a bit of a backlash effect that if you apply a disclaimer that it's AI generated, some of these disclaimers require the words manipulated, altered, etc., not just AI
Mhm.
generated.
Yep.
So inflammatory language, that it can have an almost a backlash effect on your candidate. And then on top of that, some of these disclaimers beyond just the language is how do you know that it's a very complicated way to apply the disclaimer, right? You've got your audio requirements, if you've got an image on the screen versus the video on the screen and how and when they appear. So it's not kind of like a box at the end where I think we're all pretty comfortable, or have gotten more comfortable.
Right.
And
With
it
like
just
the SEC requirements. I mean, I'll give you a great example. There was an ad, and you can find this online. There was an ad a couple of years ago, done in the Shreveport mayoral race,
mm,
where they basically took the candidate was sitting in an elementary school, and he gets called to the principal's office, and the principal gives him an F. Obviously, the candidate, the incumbent, I think it was the incumbent mayor, was not actually sitting in an elementary school classroom and like called to the principal's office. The disclaimer that says it was AI generated shows up like maybe a few couple of seconds at the very beginning of the ad. And actually, the first like 3 times I watched it, I didn't really focus on it.
mm,
Like, it wasn't until I went back and watched it the second or third time that even I realized that at the beginning of the ad, there was actually a disclaimer. Um, and that's also a great ad because that brings up this issue that's sort of in the background of, was that parody or was that a deep fake?
mm,
Does anybody really believe that like the sitting mayor of Shreveport was sitting in an elementary school and like got called to the principal's office and handed a report card with a big F? No. But was that satire or parody? I don't know. Did it actually happen? I mean, I think everybody can agree it didn't.
mm,
So I think there's a lot of, I mean, that ad just sort of, it has the disclaimer issue, it has the satire parody issue. That ad is sort of like an archetypical ad that I think, you could look to and say, what do I think about this? And I've had discussions about this ad with people all across the political spectrum, and there's not an ideologically consistent reaction. It's not like every liberal says, oh, and every conservative says, no. It's it it generates a really wide variety of opinions when you
mhm.
watch it.
Yeah.
Just frankly,
Yeah.
as a lawyer, what makes it really interesting.
Well, I'm, at the AAPC, we're often in conversation and discussion about where kind of these ethical guardrails come into play. And I think one of the challenges that we are having is because the regulatory environment is such a mess, as you say. It is kind of hard for us to figure out where the industry best practices and guidelines should live and should get us to, because we're trying to kind of negotiate both at the same time. And I think, I do think that has been a chilling effect because of that patchwork that people are uh, they either don't have the money to consult an attorney every single time they want to make an ad, right? Or they are concerned that their client is going to end up in the newspaper, or because they didn't put the right disclaimer, or they did put the right disclaimer, and then it's going to get blown up as that the candidate themselves, it's problematic that they're using AI. Because what is it? I think that the Pew report just came out, and 73%, actually it might be higher, and we should make sure that we put some notes in this, but that folks don't trust elected officials if they find out that their speech was written with AI. And so understanding what that means, not just for a candidate speech, for a political ad, the foundation is actually spending quite a bit of time and energy trying to figure out that question too. So.
Yeah, I mean, the bottom line is a lot of people don't really have an understanding of what AI is, or what it does, or even what it's capable of. And frankly, I think what it is and what it does and what it's capable of is going to shift as technology changes. I mean, if you think about it, 25 years ago, the notion of like accepting a political campaign from a credit card was like, or a political contribution by credit card was really relatively new. And so like, if you think that credit card donations online were new 25 years ago for campaigns, I mean, where's this AI technology going to be 25 years from now? And none of us, listening to this or listening to this podcast can predict that.
Mhm.
So I think that is, looking forward into the future is really tough with campaign regulation. I mean, actually, if you look through the FEC rules, they still refer to filing things by facsimile. I don't think anybody files anything on a fax machine anymore, except maybe in the medical profession.
Mhm.
But so we have these references in these laws to things that just don't exist, right? A lot of these campaign finance laws, the existing ones in most of these states, were written, in the post-Watergate era in the 1970s. Good luck finding a reference to the internet or the World Wide Web in a lot of these in a lot of these statutes. I mean, they've done some edits to them where they talk about online advertising or advertising over the internet, but like the basic statutes, a lot of them literally were written 50 years ago. So we're trying to fit modern technology into these 50-year-old laws. And we had it when online advertising, digital advertising started to overtake linear television. And so in campaign finance world or election law, we're constantly trying to fit new technology into older laws that never contemplated the new technology. And that's sort of what we're seeing with the AI transition now.
Mhm. Thank you for this conversation, Jason. I appreciate it. If for those listening, if you're an AAPC member, make sure you take a look at the Deepfake Compliance Guide that is available on the advocacy page of the AAPC.org. And thanks again. Keep an eye out for the webinar.
And that was our conversation with Julie and Jason. Be sure not to miss an episode. Subscribe to the Future of Political Consulting by the AAPC on Apple Podcasts, Spotify, or wherever you get your podcasts. And join the conversation by following us on social media at the AAPC. Thanks for listening.